criminal case number E006 of 2025, where compelling reasons were discussed. And also, I will be inviting this court to have a look at the miscellaneous application number 007 of 2023, that's a criminal miscellaneous application number E007 of 2023, Republic via DCI versus Denge Mackenzie and 17 others. Where, among other things that were discussed, Your Honor, was the public outcry in the said two cases, the seriousness of the offense, and on the seriousness of the offense, Your Honor, the parameter was set in Republic versus Pascal Ochieng Lawrence, 2014 EKLR, and among grounds that were discussed under this limb included, among others, safety of the accused, likelihood of attendance when called upon, jeopardizing community security, among other grounds, Your Honor. And also invite this court to look at the in John Zenus, ZENUS, Ungape, that is UNGAPAKE, Tembo, and two others, versus Director of Public Prosecution, M.S.C.A.CR. Appeal number 16 of 1995. Where in this case, the Supreme Court observed that the gravity of an offense can make a suspect abscond, making the said suspects a flight risk. You know, under the risk of interferences with the witnesses, I want this court to have a look at the threshold set in Republic versus Dwight, that is DWI, GHT, Sagare, that is SAGA, RAY, and 4 others. 2013 KEHC, KLR, where it outlined and discussed the issue of interfering with witnesses in details. And which was further anchored on Republic versus Jackton, that is JOKTAN, Joktan. Mayende, that is MAYENDE, and 3 others, 2012 KHC, and in which this particular case, and very relevant to the application before you, it noted that interference can occur at any stage, including at the stage of investigation. Having demonstrated to this court that the witnesses in this case are well known to the respondent and the deceased family, then the likelihood of interfering with the witnesses is not just a mere suspicion, but is a fear that is there. You know, on the issue of public interest, public safety, and the safety of the respondents, I will invite this court to have a look at the case of South Africa ample time, of which the court will agree with me that the 30 days are not even ample time, but the applicant is ready to work with the 30 days, so that they can divide the 30 days amongst themselves, the agencies, to complete the investigations, in order to serve justice to both the victims and the suspect. Your Honor, the court is supposed to be a neutral arbiter, and it only works on facts as presented. And for it to reach into a finding that is just to both sides, it must be presented with relevant facts, which can only be secured through investigations. I also request this court to look at Section 10 of the Victims Act, which speaks to the issue of protection of witnesses, to safeguard them from being bribed, threatened, and all other manner of things that might amount to interfering with witnesses. With that said and done, Your Honor, is my humble application that you find merit in this application and grant the applicant the said 30 days to conclusively work on the investigation and present the findings after the investigation. The applicant, Your Honor, is ready and willing to comply with your direction that after the said 30 days to appear before you with a status update. They are willing to comply with that. With that said, I pray that you find merit in our application and grant the applicant the said 30 days. And I rest, Your Honor.
Yes, Your Honor, on behalf of the family, we wish to adopt the submissions by the learned prosecutor and reiterate that there are compelling reasons to detain the suspects for a period of 30 days. One of the factors that you need to consider in granting that application are: one, the gravity and the nature of the offense; Your Honor, murder is a very serious offense under the Kenyan laws. And a suspect facing such a capital charge has overwhelming personal interest in evading justice, and therefore detention during investigations is proportionate to the risk. Two, there is ongoing investigations, that is forensic and scientific investigations. And Your Honor, these investigations, as already submitted, are inherently complex and time sensitive. The investigating team thus requires ample time to complete the critical aspects of the investigation. When there is equally the risk of interference with the witnesses and evidence, and Your Honor has already submitted, there is a history and the witnesses involved are known to the suspects. This being a murder case, Your Honor, there is a likelihood that the witnesses will be intimidated and there's a possibility that they will fear to come forward and give critical evidence. Your Honor, based on that, we support the application and pray that the respondents be detained for 30 days to enable the prosecution file a report as and when the 30 days lapses. And that will be all.
I'll start, then my colleagues can be able to follow up. A lot has been said, but let us now look at it deeper. When we want to talk about compelling reasons, and a lot has been said of what the prosecution thinks is compelling reasons, we will have to agree that Article 49 does not describe what compelling reasons is. So basically, when we come from that angle, we must then look for the real definition of compelling reasons. And if we have to look at it, it has to be only the dictionary or the thesaurus. And what do they say in both instances? That the compelling reasons must be so strong. They must be so forceful. They must be so prominent that you cannot ignore them. So the suspects have been brought to court, the respondents. In as much as the state would want to tell you that they have gone through Article 36A and brought them within 24 hours, Your Honor, they are not telling you the truth. So we start discrediting them from the word go. They arrest the respondents on the 29th. Today is the 31st. And even by simple arithmetic, it is beyond 24 hours. It's beyond 24 hours. There cannot be any excuse. So they start by trampling the rights of the respondents, and they come here and tell you that they want you to grant them days without batting an eyelid. Okay, they have brought the respondents to court. And they're telling you that they want 30 days. 30 days, Your Honor, even by any stretch of imagination, cannot be reasonable. Because I'll ask you, Your Honor, to look at the grounds that they have laid in the affidavit. They're telling you they want to investigate data. Please, Your Honor, how are the respondents involved in data? How? They're telling you they want to go, they're waiting for a report from the post-mortem. The last time I saw my clients here, they are not doctors, they do not consult, they don't do anything to do with post-mortem. They're telling you they want to go and check CCTV footage. Again, Your Honor, how does that become the duty of the respondent, so that they must hold them for them to achieve that? They're telling you there are motor vehicles involved, that they want to go and check the registration and the ownership. Again, how does that affect the respondent? They tell you they want the respondents to go for mental assessment. Your Honor, that is a one-day thing. It doesn't need another 29 days for that to happen. So these are the reasons they are saying, please hold these persons in custody because we want to investigate for 30 days. Then they come and tell you they have to record statements. These ones are not police officers. They are not going to help them to record statements. Not at all. They are telling you that these respondents here, if they are going to be released, there will be an issue of the mental state of the other witnesses. So, Your Honor, in a nutshell, this is what they are telling you are compelling reasons. Your Honor, how compelling are they to you? Article 49. They're the one they have come under. AG and H and I. What do they tell you? Once a suspect has been brought to court, the state must give you compelling reasons, which they have failed, and therefore, if they fail, what is the net effect, Your Honor? You must release the respondents. But then they try to modify it and tell you that, Your Honor, please hold these people in custody because it is for their own good, it is for their own safety. Let us start with that. In them saying that, have they shown you that these persons are in danger? Have they done that, Your Honor? No. Have they shown you anything from the respondents saying that we are in danger, please help us or protect us? Your Honor, again, no. So they cook up a story and tell you that these respondents are in danger out there so that they can convince you that it is better to keep them in custody. Your Honor, isn't that an imagination? If it was in social media, we would have said it's content creation. But in court here, what we needed was evidence. So what shows that they are in danger today? What shows? Nothing. Your Honor, Article 29, what does it say? That every person has a right to be safe, to be assured of security and their safety. So the same state stands here today and tells you that these people who they are supposed to protect are in danger. How do they contradict themselves and come before you? The same state that is supposed to protect these people, to assure them of safety out there, comes and tells you we cannot protect them. But Your Honor, our real danger is not even the people out there. Our real danger is the police officers. That is what we fear. Why am I saying this, Your Honor? These respondents, including the sister, who is an advocate of the High Court, were beaten by police officers. They were beaten. I went personally, Your Honor, I can swear upon this. I went personally. I spoke to the investigating officers. I pleaded with them. I implored them to take them for medical treatment. I spoke to the OCS in both stations that they were. these same officers who denied them treatment, are coming before you and telling you, please give us these people, to go and do what? Beat them again? They are more in danger from the police than the public out there. Then the same police officers, after 2 days of requesting them, please take these people for treatment, what do? They send somebody unidentified in the middle of the night to Kibera police station to go and give some pills to the second respondent to take. The same people who are beating you are now bringing you a person, they call a doctor and giving you pills to take. Your Honor, we cannot take them. You cannot trust them. You cannot trust those pills. But they still want you to give them, these people, to stay with them for 30 days. Are they being honest? And yet they are telling you it is for fairness sake. The pills are here. We don't know what this is. They don't tell you that these are painkillers or anything. They just give you. They don't know whether you are allergic. We don't know who they are or agents of what kind of person that they are. But they are telling you, we are good people. Trust us. Give us these people. Your Honor, these people might never come back alive. Not with these policemen. Not with this force that we are having. You cannot trust them. Yet we love them. Yet we think that they are the ones who protect us. Then they tell you, to just sweeten their story, that, Your Honor, these people will interfere with witnesses in this case. Your Honor, today, do you have statements of any of the witnesses that they have recorded statements with? Who are they going to interfere with? You have not been given. They do not have statements because they are telling you, we are going to record statements. But they are saying that the respondents know the suspects, the witnesses, so they are going to interfere. What are they telling you? They don't know the witnesses. We don't know the witnesses. How can we interfere with people that we do not know? Are they forgetting that there is a witness protection program that is guaranteed under the Constitution so that if they have witnesses, they can be protected by the state? You know, these fundamental rights have not just been created for the purpose of creation. They are created so that you protect these persons from these kind of state officers who are dangerous. The fundamental rights are not mere suggestions. They were put there for a reason. So that these people are not tortured, so that these people are not beaten, so that these people are not harassed. And then they tell you they are going to interfere with witnesses, but Your Honor, let us now go deep. And then you're being told, and this is crafted in a way that you do not go deeper into it. In the case of Jackton Mayende, there was actual interference and a complaint was brought to court and there was evidence that somebody had interfered with witnesses. Witness was brought to court. What have they brought here today, Your Honor? Is there a suggestion that they have even attempted to do so? No. But Jackton Mayende says that you must bring material evidence to court. That's what the decision was based on. It is the same case that you have been told of Dwight Sagarai versus Republic. That was case number 61 of 2012, not 2013. That's it. The court said, and this was Justice Correll, she said quite clearly that for you to bring an issue about interference, you must place material before the court. Your Honor, the catchword being must. It's not an imagination, it is not a suggestion, it is a must. That is established law. So they can't come here and tell you we imagine. Your Honor, today, let us use facts because this is a court of law, not imagination. Your Honor, let us look at a similar case. Case number 48 of 2012. David Richard Alden versus Republic. Luckily, I'm in almost all these matters. In the case of David Richard Alden, Justice Lesita, she then was, said one thing. You cannot come to court and say that there will be interference, because the sky will be the limit. Anybody can say anything, and they are saying anything. That is what they are doing today. So, Your Honor, because of an imagination that these people are going to interfere with witnesses, deny these people their rights. Your Honor, not today, please. They need to go back and reread what the state said. But then again, they are trying to tell you that they will abscond. That the real reason that now that the case is there, the case is strong against them, they will run away. In the same two authorities that I have indicated, the court said that in case you want to suggest that somebody wants to abscond, you must also place material before the court. You must show that they have bought tickets, or they have prepared to travel, or they are speaking to travel agents. Have they done that today, Your Honor? They have not. But yet, they want you to go with the imagination they are giving you. Your Honor, today, please, let them go back, and I say, to reread that law. Then you are being told that there is public interest, and the public is aware about this matter. This matter has become high profile. Your Honor, high profile how? In Oyamo versus Republic, that is case number 113 of 2018, it's a Court of Appeal decision from the Obado case. What did the court say? You must also show the interest that you are saying. You must prove it. You cannot come and say it only, but also give its backing. But they want you to keep an old lady like this, who is 75 years old, 75 years old, and they forget that Article 57 says, treat them with dignity, not with the lies that the prosecution has been given by the investigating officers. That is not dignity. Dignity is to treat her the way she's supposed to be treated. And that must go with Article 28. It is inherent. You must treat all the people with the dignity they deserve, and Article 28 also says there is inherent dignity, which somebody must preserve for themselves. And that goes for the second respondent. Today, Your Honor, let me reveal, he is an advocate of the High Court. Luckily, he was Mr. Dunstan Omari's classmate.
Yeah, you can throw an affidavit.
Yes. So he is an advocate of the High Court. They forget one thing, again, Your Honor, let me just say it this way. They forget that he is running an office. As an advocate, he is supposed to attend to clients. He has got cases coming up next week. And the two respondents have a matter related to this case that was mentioned to you that is coming up next week. But what do they want to do? Keep them in custody because they are in favor of the other side. I will stand here and say that that is what they want to do. And they know it. And they tell you that the respondents evicted the deceased from her property. It is not true. The affidavit says a long-standing case. Your Honor, this is a case for 2026. The eviction was by a court order, lawfully supervised by the police. The case had been determined. The property belongs to the first respondent, not to the deceased. How do they cook up this story and imagine you will believe? If they want to come and get equity today, Your Honor, let them come with clean hands, not falsehoods. This is a court of law. But you are being told that you can still hold them for about 90 days. Your Honor, ulisikia wapi? 90 days. You can only get 90 days if you cannot get what you need to do within the 30 days. But they are telling you, we are happy with the 30 days so that you can see that they have given us a concession. There is no concession there. Today, when they went, the day they went to pick the respondents, they picked them from their home. They had not absconded or gone anywhere. They went to the house and picked them up. The only thing they did, the extra, is beat them up. Mercilessly. The daughter here has got a P3. the registration of the assault on these other respondents who are here could not be recorded. Why? Because it's a cartel of police officers. Any report police officer cannot be allowed. They will not. They went to the DCI Langata. I called personally and sent the advocate in court. But for these other persons, even in the stations, they refused to record it in the OB. So if the second respondent fell today, it's another Albert Ojong kind of case. But they will not. So, Your Honor, now that we have found out that their stories are not genuine and cannot hold water, they forget that this must come to Article 19. These fundamental rights are not for the police officers, are not for the state. They belong to the accused persons and suspects whenever they are apprehended by police, so that they are protected. And the court is bound under Article 20 and 21. These inherent rights, these fundamental rights, once the court notices that they are there, the court must start by wanting to grant, not to deny, as the state would come with an affidavit to show you. So, Your Honor, while they say that they have now treated our client, right to treatment, Your Honor, does it exist? Yes. Right to medical services? Yes. So we are saying, Your Honor, while they want them to be investigated, please release this person so that they can also go for medical treatment. Not one that they have created from somebody we don't know, so that they can be treated. You can't go and tell somebody, we want to investigate you, to write your statement when they are in pain, when there is suffering, and you say that it is free will. It cannot be. Your Honor, now that they are refusing, activate Article 23. 23 says that now we can come to the court, because when they have refused, we come to the court. You are the arbiter. Now that we know that they don't want these people released, Your Honor, please help us. They don't have to be in custody to be investigated. They can report on a daily basis. These are family members who stay in the same house. They live together. This is mother and son. But they are being told, because some people used a motorcycle and they absconded, and they disappeared, that these people will help them to run away. The people have run away. The people were not found at the scene. But you are being told, please, these people know who they are. It is not true. But you are being told, evidence is strong in this case, and therefore use that evidence to deny these persons to go home. Your Honor, Oyamo versus Republic, I am repeating, Court of Appeal, case number 113 of 2018. What did the court say about that? The evidence that is being brought to you and being told that they were identified and that they were at the scene and they did all these things, Your Honor, cannot be brought into this court, cannot be tried at this particular stage, and therefore the truth cannot be determined at this particular moment. And the Court of Appeal said it is unfair to ever try to use that situation. Do they have a Court of Appeal decision higher than that? Let us not use an issue of what they call probability, because, Your Honor, the fundamental rights are as exact as they can be. They are not probabilities. You're being told, because there are multi-agencies that are being used, therefore please give us 30 days. So what, Your Honor? Multi-agencies are who? They are officers like anybody else. Those multi-agency officers can go to and investigate what they are investigating. If they are dealing with data, whatever they are dealing with, they can go ahead and do it. It does not require 30 days. It does not require these people to be in custody. Now, Yana, I'll just mention before I leave it to my colleagues, I'll go to paragraph 13 of the notice of motion, paragraph 13 and 14. And they're being told, that the deceased, while she was driving on 7th of July, she was driving along Gong Road near Junction Mall, 2 unknown men, Your Honor, that is the catch-all. 2 unknown men riding on a motorbike pointed a gun at her. She then ran away and filed a report. Your Honor, 7th of July. Today, we are on 31st. After this incident, the deceased reported to the police and her husband, and that the pilot passenger who was among those was identified as the second respondent. Identified by who? From 7th to 31st, why hadn't they arrested him for that issue? Why are they making it so dramatic now and bringing up an issue that does not exist? Where is that statement where she identified and mentioned that it was Chris who is here in court today, so that we have it and know that it is true? Your Honor, this cannot be true. And that on 27th, while driving from a homestead, she was trailed by unknown men. Your Honor, unknown, everything is unknown. So because some people who had a motorcycle had a gun, which has not been found with the second respondent, so they should carry the cross. Because the police are incompetent, they cannot investigate a matter from the 7th until today. If they cannot do such a simple matter of a threat from 7th until 31st, what are they asking for 30 days for? They can do nothing. And I'm repeating again, please do not allow these respondents to go back to those policemen. They'll be beaten. It is given. Yes, proceed. It's okay.
Thank you, Counsel. Your Honor, Katunga Mbuvi. Your Honor, I wish to associate my submissions to the good submissions made by my good friend in reference to this matter. Your Honor, all that I wish to add in this matter is that there is a violation of suspects' rights already. The suspects were arrested on Wednesday. Today is Friday, 36 hours down the line. And all that the IO or the prosecution is doing, Your Honor, is to perpetrate that illegality. Your Honor, this is a court of law, a court that cannot perpetuate an illegality. Your Honor, on paragraph 21, read together with the paragraph 22 of the supporting affidavit, 21 of the supporting affidavit, together with paragraph 22, clearly states that the killers in the offense before this court are known. They are saying they were holding a pistol and there was a motorbike. Someone was riding a motorbike. That clearly exonerates the suspects before this court. Your Honor, Article 50 of our Constitution deems or presumes the suspects innocent. Your Honor, if you go through the affidavit, the suspects have been condemned and hard. It's like giving a dog a bad name, then proceed to hang it. Your Honor, you cannot allow your court to be misused that way. The application before you has no merit. Your Honor, it has not demonstrated that the suspects are flight risk by any chance. There is not even a paragraph to that effect. Your Honor, they have not mentioned that the suspects have a fixed abode, they have a home at Karen, and another home at Machakos. They omitted that intentionally. All that they are telling you, Your Honor, is that they are going to interfere with witnesses. Your Honor, you've not been given the list of those witnesses that the suspects are likely to interfere with. Your Honor, as I had submitted, this is a court of law. The application before you is speculative in nature. They are talking of witnesses that are not here. You've not been given the names of those witnesses. We don't know where they are. If we put the person who deposed this application for cross-examination, Your Honor, I'm so sure they will not give you the list of these witnesses. But they are asking you, please do not release this person because they are likely to interfere with unknown witnesses. Your Honor, this is a court of law. You should not buy that. Your Honor, again, on the issue of land, they are saying there was a dispute. And they are saying you should not release the accused and suspects because there was a dispute. Your Honor, that was a concluded case. And as my good friend has submitted, there was eviction. And the eviction was supervised by the same police. Again, now they cannot hold the suspect before your court on the basis of something that has already been taken. And this is before another court. If there is anything in that court, Your Honor, we know the law. There is a law of contempt. They can go before that court. But not to use your court in another case where it was concluded. Your Honor, that is not the practice. Your Honor, we've been told that there are forensic and data materials with CCTV cameras that the investigations are carrying on. But they refused to tell you that those materials are in the hands of the same police. Unless they are doubting their own people, if they are doubting their own people, Your Honor, then you can hold the suspect here. If the CCTV cameras, the ballistics, and the data are in the hands of the suspects, Your Honor, you can retain them. But these materials are in the hands of the same police who are investigating this matter. Your Honor, that's why we are saying the application before you has no merit. It cannot persuade you, Your Honor, in any way to detain or to continue perpetrating an illegality or something that is unconstitutional. Your Honor, Article 49(1)(f) gives the mandate to any court. This is a cardinal law that the suspects are supposed to be held not more than 24 hours. Now we are on 36, they are not mentioning that. Your Honor, all that we are submitting is that you release the suspects, maybe with a condition that they be reporting to the nearest police station, that is Adi police station, on daily basis, if need be. Your Honor, they are ready to cooperate with the IO, and they've cooperated very well. Your Honor, you've never been told whether the accused have any passports or not. There's nothing, there's no paragraph to that effect. If you go from paragraph 1 to the last paragraph, Your Honor, those are the compelling reasons that are known in the books of law that actually can sustain the allegations under section 36A 1 to 5. But in the absence of that, Your Honor, the application has to fail. And for the application to fail, Your Honor, these people have suffered. I urge you, with due respect and respect of human rights, that they be released on any condition that you will give. That's all, Your Honor. I leave it to my good friend to continue.
Your Honor, if it please the court, my name is Angela Molwa. I'm an advocate of the High Court. I've been in practice for 26 years. I'm an associate with Katunga. Angela Molwa. Angela Molwa. I'm an advocate of the High Court. I've been in practice for 26 years, and I am an associate with Katunga. My colleagues have done a very good job of highlighting different matters. Mine is to focus on only one issue in this matter, and that is the systemic police reign of terror and intimidation that has been going on since Wednesday, 29th, up to today as we speak. On Wednesday, 29th at 11 p.m., I was present. As I said, the first respondent is my mother. She ran for governor, Machakos, 2022. She's a well-known member of society. She's also a party leader of a political party. The second respondent is my brother. He's also an advocate of the High Court. And as been mentioned, he was a classmate with the renowned Dunstan Amari. As I said, I have been in practice for the last 26 years. I was at home in Karen on the 29th when the police entered the property at 11 p.m. And from 11 p.m., Your Honor, until 3 a.m., the police carried out terror and intimidation on myself, on the first respondent, on the second respondent, on my other brother, who is here in court, on my other sister, on the entire family household, 5 members. They refused, for the 5 hours they were on the scene, they refused to identify themselves. We repeatedly asked them, who are you? They were in plain clothes with masks. There were about 20 to 25 men carrying handles of jambes and carrying guns. They refused to show their faces to us. Immediately they entered the compound that they were from Hardy police station. So the gate was opened to them willingly. When we went out to meet them, we found 20 to 25 men, not in police uniform, with masks, hiding their identity. So for those 5 hours, we attempted to, we tried to ask them, what are you police officers? What are the charges? After 5 hours, they took the first respondent and the second respondent into custody. They told us they were taking them to Nairobi Central area. I requested to follow them. They physically restrained me from following them. They also took the keys for all vehicles in the compound so that nobody could follow the first and second responder to know where they'd been taken to at 3 a.m. in the morning. And we managed to locate the 2 respondents, not at Nairobi Central area as they had told us, but at Kilimani and at Kibera at 4 a.m. in the morning. As late as today, they have parked 3 vehicles in our compound with civilian license plates. They have refused to leave our compound. They did not state the reason why they are in the compound. We were called while we were in court and told they have been walking around the compound claiming they are looking for the murder weapon. And it was not until senior counsel here called one of the officers and told them, you cannot conduct a search in the absence of the suspects, in the absence of counsel, because of the bias of planted evidence. They still remain in the compound right now. To what end, we do not know. And as late as last night, Council mentioned that they tried to give medication to the second responder, to which he refused. What Council also did not mention is they attempted to get the second respondent to write a statement that he has no bruises, to which he refused to sign that statement. I myself, who has not been in custody, have gone to several police stations to get an OB. I have bruises that I proudly bear as an officer of the court, as I sought to restrain them from attacking my family. And the audacity that needs to be brought to light is that for those 5 hours, these men told us, we are the police. When we told them, are you the police? Who are you? What is your name? What is your rank? They told us, we are the police. We are in power. We will do what we want. And I came to learn yesterday when they wanted to take statements that the IP Odwar, the IO Odwar, and the IO Mwangi, I recognize their two faces as the ones who led the contingent of 25 men, and who openly told the men, wanyamazishe. And every time they told the 25 men wanyamazishe, they rained more blows on us, kicks on us. I can barely walk because of my left leg. It is bruised. And all manner of indecencies. So mine is simply to say that it is preposterous for the police to say that the best place of security is the police station, not after the terror and intimidation that they have rained on us from Wednesday up to today as we speak. Thank you, Your Honor.
Thank you. You know, based on what you have heard, I hereby make an oral application that the two be released on reasonable cash bail and bond terms on the following grounds that I'll summarize my colleagues have put to you. Number one, police cells are unsafe for the two. And therefore, it will be a risk venture for this court to remand the two in any police station. And because the law only recognizes two institutions for holding people in conflict with the law, that's prison and the police, they cannot be taken to a prison. Therefore, I lay the basis that you release them on bail. To Your Honor, this is an advocate, senior advocate, that has narrated an ordeal before court. I don't know where LSK is to deal up with this matter instead of dealing with the judicial officers to boycott going to appear before court. This is a serious issue that needs to be investigated by this court. A court officer also falls under the constitutional provision of the marginalized. Had you dealt with her and convicted her, the Judicial Sentencing Policy Guidelines recognizes age as a critical condition. She will not go for life imprisonment, or she will not go for more than 2 or 3 years. That is enough ground to release her. Fourth, Your Honor, the first respondent is a presidential candidate for 2027. She has declared an interest pursuant to Article 38 of the Constitution to stand for the position of the President of the Republic of Kenya. And this is a scheme from the ballot. The daughter, councillor, said she contested for the governor's seat of Machakos, grant her bail. The second respondent is a classmate of mine, and I'm conflicted. We went to school together, did law together, admitted together. He runs a law firm. He's an officer of this court. An attempt to incarcerate him, his clients will not have access to justice. Your Honor, they might think he's on strike when he is incarcerated. Allow him to practice his law on the principle that he is innocent until proven guilty. The sixth issue, Your Honor, that comes into why you should grant bail is that the first respondent is a divorcee. The deceased took over as a wife. The constant is the former husband and now the current husband for the deceased. Must a divorcee still be pursued after 7 years? Courts pronounced and gave a divorce decree, nisi and absolute. If she had a plan to kill, she could have killed immediately. The divorce was present. She was. No, no, I'm sorry. The daughter tells me she was divorced 20 years ago. She can't be bitter. 20 years ago. The son was a toddler. It's not now they can decide to revenge after 20 years. You know, I bring also the eighth ground because of age, and I appeared before one of the courts around here, the famous case of Dr. Obwak. May God rest his soul in eternal peace. We pleaded with Cliff Mbithe, with Shadrach, with the other advocates. This old man is likely to die. And true to that, he's resting. This lady falls in that age category. If detained and such eventuality happens, the blame goes to the judiciary, not the state. Similar matter of Gakuo, the former county clerk of Nairobi City, pleaded age and health. He was incarcerated. He rested in peace. These are now the compelling reasons, Your Honor, that we have presented to you. To grant bail. The averments by the state as compelling reasons put on a scale of justice. You know, you'll get favor in our submissions. That application I've made to release the two on bail. What is the case law I'm relying on? The Court of Appeal decision of Caspar Oyamu. It is commonly known the Obado case that went to the Court of Appeal. Governor Obado was released on cash bail at the High Court. Others were denied. That's for the benefit of the students who are present. Those ones went to the Court of Appeal and cited the question of discrimination and cited the question that if Governor Obado could be released with the immense power of a governor who had the tools to intimidate witnesses, and whose witnesses in this matter were employees of the county government of Migori, he was released. What about us, mere mortals? The Court of Appeal released them and gave conditions. Your Honor, to contextualize concerning those in the dock, release them and grant very, very serious conditions. The state, I'm sure the state worked all over to get an authority from the Court of Appeal to counter what we have presented. They only got authorities from the High Court. And the principle is that the High Court's authority is superior unless they bring the Supreme Court authority. You know, these people are crying before you. These people are looking at you. The darling of the court is an accused person. Cliff tells me the favorite child of the court is a suspect or an accused person. And only their rights are constitutional rights because they are blood that is red running in their veins. The state has no blood. The state has no feelings. And that's why the Constitution never gave the state any right at all. You want to kindly release these people who have been brought here to settle different scores. I rest my case. I leave it to Shadrach to file.
Your Honor, with your permission, I will endeavor to be very brief and very precise with my submissions as I take cognizance of the time and of course the requirement that the court has to return a ruling to permit our client the opportunity of securing their liberty. Your Honor, at the very outset, I begin by sending my very sincere sympathies to the family of the deceased, Dr. Victoria Mutiso. It is not lost on us that the desire of justice is for the killers of the late to be brought to book. In any event, the law, particularly the Blackstone's ratio, recognizes the need of at all times guarding that it is the best interest of justice for 9 accused or 9 guilty people to be set at liberty than to imprison an innocent person. Your Honor, the application that lies before the Honorable Court, supported by an affidavit sworn on the 31st day of July 2026 by Corporal Romana Oduor, seeks essentially to limit the liberty of the suspects before the Honorable Court, the respondents, for a period of 30 days. Your Honor, grounds have been advanced to justify the relevance of the application and the request that has been made by the prosecution. While we note that it has been allegedly made under certain provisions of the law, Your Honor, it is not enough for the applicants to just make references to particular provisions of the Constitution and the Criminal Procedure Code without necessarily laying before the court material facts, so that those material facts looked together with the law would justify the grant of the order that has been sought before the Honorable Court. I submit with respect that a very keen and very generous interaction with the grounds that have been levied before the Honorable Court leaves so much to be desired. At the very least, we do not find any justification whatsoever from the grounds deponed to warrant the denial of the liberty of the suspect before the Honorable Court for the period that has been sought. Your Honor, applications such as this, guided by Section 36A, are not to be allowed as a matter of course. The court is under duty, to balance the quadruple rights that are competing before the Honorable Court. The quadruple rights are, Your Honor, the rights of the suspect or the accused, those of the public, the rights of the victim, and usually the strong desire to preserve the integrity of the administration of justice. Those are the 4 competing rights that are before the court today, and the court is called upon to balance them. As the last hope or guardian of our Constitution. This application is not novel. In fact, superior courts have had the opportunity of creating a path through which this Honorable Court should walk through today. With me, Your Honor, I have 2 authorities that I will wish to supply the Honorable Court with. The first one is the famous case of the Michael Rotich, decided by my Lord Justice Luka Kimaru, as he then was. This is miscellaneous criminal application number 304 of the year 2016. My Lord, who has since been elevated to be serving us at the Court of Appeal, warned against applications made by police officers who, upon arresting someone, rush to the Honorable Court only to seek for time or further time to detain these people for longer than is necessary. In fact, my reading of the supporting affidavit before the Honorable Court, particularly, Your Honor, it has been deponed that one of the reasons, this is paragraph 27, Your Honor, of the affidavit, that one of the reasons why you should detain them for 30 days is for the reason to afford the investigating officer the opportunity of submitting them before a hospital for mental assessment. So this tells us from where we sit that, of course, the investigations are predetermined. The investigators have decided that these people are guilty of the offense of murder and they should therefore be subjected to a mental assessment. So, Your Honor, if they have already decided they should be charged for the offense of murder, does it then, or does it not run against common sense for the same investigators to be asking for 30 days to continue detaining them for an offense that they have already concluded that they have committed? In other words, Your Honor, the case of Michael Rotich tells us that if the investigator is persuaded that offense has been committed by suspects, they should resist the temptation of making an application such as the one that lies before the Honorable Court to continue detaining persons that should ordinarily be charged. Relying on that authority, I urge the Honorable Court to echo the sentiments made by my Lord and to warn the investigator that if they have enough and sufficient evidence to charge the suspects, they should proceed and charge them as opposed to asking for a pre-trial detention of 30 days of the suspects. Your Honor, my second authority that I will wish with humility to direct the attention of the court and for the court to pay keen attention on is the famous case of Mheshimiwa Sudi Oscar Kipchumba versus the Republic. It is not a very lengthy authority. It is one that was decided by my Lord Justice Professor Joel Ngugi, who has equally been elevated to the Court of Appeal. Your Honor, of particular importance is paragraph 26 of that authority. Sorry, paragraph 24. Paragraph 24 of that authority has since set principles that should ordinarily guide the court when called upon to make a determination of applications such as the one that lies before the Honorable Court. To summarize, is that the prosecution has the duty of making an application such as the one that lies before the court in good faith. My senior sister learned counsel and the daughter of the first respondent and a sister to the second respondent has gone to a great length to elaborate and to explain to the Honorable Court what really transpired on the 29th day of July 2026. Those grotesque scenes that are still visiting her and the family, the very presence, uninvited presence of police officers at the compound of the respondents, longer than the time that they had gone to cause the arrest, is telling that the applicants of this application are not making this application in good faith. There are ulterior motives that are meant to be achieved. The second respondent has tried to narrate to me what he undergone on that fateful night. The torture that he was taken through, the kind of assault that was visited on his head by the police officers using the head butt of the gun, knocking his head, his chest, and his private parts, all in an attempt to intimidate him, so that when called upon to answer to certain questions, he will respond in a way that was predetermined by the investigating officers. Your Honor, these are the very same people currently before this honorable court pleading with is that, Your Honor, when invited to limit the liberty of a suspect, the court must first develop an attitude seeking to aggrandize, to generously promote and to protect the liberty of the accused, as opposed to an attitude that seeks to diminish the enjoyment of this liberty being enjoyed by the respondent or the accused person. So that is an attitude that the court must develop. The court must therefore ask itself, in line with the provisions of Article 24 of the Constitution, now that it has been called upon to limit the liberty of the accused for a period of 30 days, are there less restrictive means that can be utilized by the court to ensure that the investigating officer, Madam Oduor Romana, has ample time and opportunity to investigate the offenses alleged, while at the same time granting the suspects their right to liberty, even in the face of charges of murder. It has been said that the public is angry about the death of Daktari. Indeed, the public must be angry. But it cannot be the same reason advanced by the prosecution that because the public is angry, then these respondents must, as a matter of course, be denied their right to bail. Your Honor, I submit that it is the same public on the 27th day of August 2010 that decided to promulgate a constitution granting all, without exception, their right to bail, whether or not you are charged of murder, suspected of murder, or treason, or any other offense. Your Honor, the principle I have directed the court with humility to look at. I invite equally the court to also take a read at paragraph 36, section 36A, 5. Sorry, 4. That, Your Honor, it is incumbent upon the court, as the situation so demands, to impose certain conditions if it is not satisfied of releasing or having the release of the suspects unconditionally. Your Honor, you have the power and the might of directing that the respondents should refrain from visiting a certain area, speaking to certain individuals, in an attempt to balance the rights of the four parties whose rights are competing before this honorable court. Your Honor, lastly, as I come to the conclusion of my submissions, the instructions I have from the second respondent is that at the time of his arrest and that of his mother, the first respondent, the investigating officer confiscated his motor vehicle, took into their possession his logbook. They took mobile phones that serve as his tool of trade in his private practice as an advocate. Additionally, they also unlawfully confiscated his LSK identity card and his national ID card. Your Honor, I'm equally informed even the birth certificates belonging to the accused, the suspect, sorry, were also confiscated by the investigating officers. Your Honor, by whichever stretch of imagination, there is no connection between the offense that is being investigated with the items that have been confiscated by the police officers. The credit cards that are in the possession of Romana Odur, Corporal, and his ID cards do not serve or cannot serve any part of the investigations. We'll therefore be asking that even as we plead with the Honorable Court to consider releasing the respondents on reasonable bail or bond terms, that an order equally be made directing Corporal Romana Odur to unconditionally and immediately release those personal items belonging to the respondents. Your Honor, I'm informed that our clients are not feeling well. It is equally important for their safety or for their well-being, for that matter, for them, Your Honor, to be released and be given the opportunity of visiting a doctor. Your Honor, I will be remiss on duty if I don't mention one thing. A reading of section 36A7 directs that an order to detain a suspect can only be made first for a period of 30 days. It is important that the court also takes notice of the time and the day of arrest while computing these days in the unlikely event that the Honorable Court is to grant the prosecution days. In the unlikely event, Your Honor, that you grant them what they are requesting, which I know there is no ground or justification to do that. It is important because we also have students before the Honorable Court. Sometimes when investigators make this application, they do it knowing that sometimes we might not take into consideration the day that accused persons or suspects were arrested. I will urge that you take cognizance of that, and most importantly, dismiss the application that is before the Honorable Court and commit the suspects to any reasonable terms. That is all from me, Your Honor. Thank you.
That's prosecution in reply.
Your Honor, It is our submission that the rights under Article 49, 1H are not absolute, and that the right to bail is not an automatic right. The only rights that are absolute are under Article 25 of the Constitution. The state has complied with the requirements detailed and set out in Section 36A of the Criminal Procedure Code. And in response to the issue that the witnesses have not been identified in the affidavit, under Section 20 of the affidavit indicates that the key prosecution witnesses include members of the deceased family and other persons connected to the long-standing land dispute that forms part of the investigations. These persons are well known to the respondents. Your Honor, the husband to the deceased is also listed as a principal witness in paragraph 22 of the affidavit. The witnesses will be vulnerable as their identities are known, and any intimidation or coercion will be prejudicial to the investigations being carried out by the Homicide Bureau. Your Honor, it is not true that the accused persons, the respondents, were arrested on the 29th. It is clearly indicated in the affidavit in paragraph 18 that they were arrested on the 30th of July this year and booked into lawful custody at Kilimani and Kibera police stations, and the OB numbers are clearly indicated, Your Honor. Your Honor, on the issue of granting bail and the suggestion that they be reporting to the investigation officer, Your Honor, I wish to retaliate that reporting conditions will simply not work and will not serve the interest of justice in this matter. Your Honor, the respondents are being investigated for the offense of murder, which is a capital offense. The state is operating under a complex forensic timeline. There is a multi-agency effort to investigate this matter, Your Honor. Logistical coordination of multi-agencies, considering the scope of the investigations and the areas yet to be covered that we have laid out, will not be possible if they are not in custody. The respondents are not in custody. Your Honor, on the issue of the respondents being a flight risk, Your Honor, given the gravity of the offense that is being investigated, this is a capital offense and the sentence is well known. This makes it a high flight risk for the respondents. Your Honor, Article 27 of the Constitution guarantees equality and freedoms for all. It covers equality before the law, and everyone presented before this court is equal in the eyes of the law. Your Honor, failing to safeguard the integrity of the investigations due to the status of the respondents would be discrimination. Your Honor, it is our submission that there must be equality in the eyes of the public, and that this court, we hardly urge it to exercise its discretion judiciously. Your Honor, one of the counsels has raised issues as a member of the family that they were victims of police brutality, and we wish to respond that no tangible evidence has been placed before this court to substantiate the allegations. These are unsubstantiated allegations, and we urge the court to treat them as such. She is a counsel, and there are several police stations between Hardy, Karen, up to Upper Hill. There's even a police station in Milimani. No report has been made. No medical report has been presented before this court. Therefore, Your Honor, we urge this court to uphold the application by the prosecution and grant us the 30 days period that we are seeking, Your Honor.
A very brief rejoinder. Your Honor, let me start by giving a response to whatever has been submitted by Counsel Shadrach. I was following him very keenly, and his submissions was very interesting until the point he decided to become very economical with information. You know, in our application, it's very clear. We have not indicated we have enough evidence to charge the said persons. We have said, give us an opportunity of 30 days to conclude the investigation so that we can get sufficient evidence as required by the law to charge and make a decision on the same. Counsel was flowing very well up to the point where he indicated that, or up to the point of where he noted that we require evidence in order to charge. And I want to appraise him for that, knowing that we need evidence. And that's what we are asking this court to grant us. Give us time in order to get this evidence that Mr. Shadrach has really noticed that we need in order to make a decision. Furthermore, Your Honor, Mr. Shadrach pointed you to section 36A(4), where the law says that the court can release the suspects or put conditions, but he failed, Your Honor, to go to the next limb after that, which says the court can place them in custody. That is the law, Your Honor. The same law he's reading is the same law that tells you, Your Honor, and vests authority on you that you can place them in custody. And when you go to subsection 7, it gives you the period, Your Honor. In the first instance, 30 days. So he was economical with information at that point. Your Honor, the items that were taken, they were recorded in an inventory. And some of the items that Mr. Shadrach mentioned to you, including birth certificate and credits, are not part of the inventory. And any other thing that is lawfully held and recorded in the inventory forms part of the investigation. And the law, Your Honor, is very clear. And it's established law that the court should not, unless it's very necessary, interfere with the investigations. The court should not interfere with the investigation. Whatever Counsel Shadrach is doing is inviting you, Your Honor, to interfere with the investigations, of which I'm urging you to refrain from doing in order to serve justice. Your Honor, as I conclude on the reply on Shadrach's application, I want this court to note that in the application, we are not asking for custodial orders just for the sake of having the said suspects in custody, Your Honor. It's clear information that our prisons are actually congested, Your Honor, and we will not be asking for such orders for the sake of it, Your Honor. We have given sufficient reasons as to why we are requesting for the 30 days. In order, Your Honor, to get this evidence and present and also offer a fair trial to the suspects, if it gets there, of which a fair trial, Your Honor, under Article 25C, it cannot be limited. Under Article 25C, Your Honor, it cannot be limited. They did not want to tell you that, Your Honor, that in order for us and for the court to offer and guarantee a fair trial to the suspects, we will need evidence. We'll need to provide them with the materials that they might use, as provided for under Article 50, Sub-Article 2. Your Honor, under Article 50 guarantees a fair trial, of which can only be given and accorded to the suspects if proper investigations are carried. And that's what we are requesting you to allow us. In fact, we are requesting you to give us 30 days in order to accord the suspects a fair trial. Your Honor, the principle of the Constitution that the Constitution should be interpreted as a coherent and interconnected whole than isolated parts, popularly known as the holistic interpretation, requires that the Constitution to be interpreted as a whole, not to select what part of the Constitution favors your situation. Your Honor, you have been given a number of fundamental rights and freedoms under Article 29, 19, 21, 23. In fact, under 23, Your Honor, you have been invited to commit an infringement of the Constitution, the same Constitution that places you there under Article 169. You're being told to infringe it, Your Honor. How? By offering remedies under Article 23. Your Honor, the law is very clear that this court derives its mandate from statutes. And one of these statutes, Your Honor, is the Magistrate Act. Under Section 8(1), the Act dictates to this court up to what point it should entertain an infringement to a fundamental right and freedom. And it goes ahead to point you, Your Honor, to Article 25A and B only. A and B only. No any other right or freedom. Your Honor, therefore, I'm urging this court on the issue to do with Article 29, 21, 19, 23, the court lacks jurisdiction. It lacks jurisdiction, and what the law classicus case in owners of the motor vehicle, Lillian S versus Caltex Oil, 1989. You know, that very essential jurisprudence of this country tells you to down your tools as far as entertainment of infringement of rights is concerned. Don't yield to that call of entering into those dangerous waters, of entertaining what the law has told you, Your Honor, to refrain from doing. Your Honor, Senior Counsel Mbithe, as he was submitting, he referred to our application as a content creation. And Your Honor, this court will have a time to sit down and weigh, of which the court will agree with me that Counsel Mbithe, Senior Counsel Mbithe, has treated this court to a cornucopia of the theatric performance by Your Honor telling you that we have not submitted reasons, compelling reasons, as to why the persons before you should be put in custody, dismissing all our grounds, only Your Honor to tell you the reason as to why they should not be placed in custody is because, number one, Your Honor, the first respondent, as per Counsel Omare, is a presidential candidate. What are you being told, Your Honor? That you should not place her in custody because she is a presidential candidate. Number two, that the second respondent is a classmate to Counsel Omare. Your Honor, you're being told that you should not place him in custody because for the mere fact that he was a classmate. I'm sure, Your Honor, you are also a classmate to someone. I was a classmate to someone. Mbithe was a classmate to someone. And we should not limit justice simply because we had classmates. Now, if that is the case, Your Honor, what will happen when it crosses to a level now where justice is needed to be given against our wives, husbands, children? What will happen to this court?
Your Honor, maybe I should just indicate this is a misinterpretation of what we said. We said clearly he is an advocate. Luckily, he was a classmate to Mr. Dansamari. But the issue was he's a lawyer and he's got work to do even in the course of next week. Please.
You know, that is interesting.
That is why you are not my classmate and you could not have passed.
I appreciate I'm not his classmate, Your Honor.
Just proceed.
Thank you, sir. So, Your Honor, what I'm saying is that the grounds that you have been given, they fall categorically under a cornucopia of theatric performance. And you should not entertain that kind of reasoning, Your Honor. We are here before you because of law. We should place facts before you for you to find a conclusive reasoning. Your Honor, you have been given a case law that they are referring to every now and then, popularly calling it Obado case, the Oyamo case. But our application, Your Honor, all the grounds that we have pointed out in our application, all of them, they have been addressed conclusively in the Mackenzie case. Conclusively. And therefore, I will be urging this court, as it retires, to have a look into that case, the Mackenzie case, whereby all the other cases that have been presented to you by the defense counsel, by the counsel representing the respondents, have been analyzed by the learned adjudicator in that particular case. Your Honor, as I conclude, so, Your Honor, something else that I want this court to have a look at. When Senior Counsel Mbithe was submitting, Your Honor, he talked of what need to be proven before you. And, Your Honor, is a settled law that a custodial application, Your Honor, although onus lies with prosecution to prove and give compelling reasons as to why we are making the application, we are not required by the law to do that beyond reasonable doubt. It's a settled law that such an application is based on balance of probability. Whatever we have presented to you, Your Honor, goes beyond balance of probability. The application carries strong points that were addressed even in the William, a case that I gave earlier, involving the murder of MP Ongondowere, where the court addressed all these grounds that I have presented before you. Your Honor, under section Article 24, which talks of limitation of rights, it does not capture the right and freedom to liberty as a right that cannot be limited. It can be limited. And it only gives conditions under which it can be limited. And before you, we have met the conditions of asking you to limit the freedom of the said suspect for 30 days in order to conclude the investigations. And you know, don't yield into the call to overlook and weigh and dismiss this application on the sole purpose or reason that the first respondent is 75 years old. You know? Your Honor, criminal liability is personal. You know, then does it mean that if a 90-year-old person commits a crime, we should pardon them simply because of their age? I beg the court not to entertain that thought and deliver justice. Your Honor, that counsel and daughter to the first respondent and a brother to the second respondent. Has given court a narration of what transpired, but no tangible evidence has been presented to you. And again, I would ask this court, you've been told that the prosecution have not presented any tangible evidence. But again, they go ahead and give you a narration that is not supported. You have been told, Your Honor, that 2 motor vehicles entered into the compound carrying more than 25 men. Your Honor, we have not even been told what kind of a motor vehicle. It could have been a Suzuki Alto, a Dayasumira. It cannot carry 25 people, Your Honor. And if indeed the way she was stating that there was terror, at what point did she get that piece of counting 1, 2, 3 to 25 men? Your Honor. Your Honor, you have been given so many narrations in relation to that. We have not presented any form of evidence before you, Your Honor. But we have indicated that there are some exhibits that were collected from the second respondent upon the arrest, and which are being investigated if they are the one which was shared with the perpetrators, because the said exhibit relate to the deceased. You know, if that is not sufficient evidence that has been tabled before you, I don't then understand what other evidence will be required. And furthermore, Your Honor, we have not conclusively said that the suspects are accused persons, and that's why we are even referring them to suspects opposed to the counsels who are calling them accused. Because to us, they are still suspects. We are presuming their innocence. And that's why we are asking this court to allow us to do investigations before we go to the next step. You have been told that they have cooperated well with the investigating authorities, and being told that they have cooperated very well, and then again you are told they were beaten. You know, how contradicting can a statement get than this? That they cooperated, and again you're told they were beaten, and no evidence is presented before. And then this court is being misled that a person must have a passport in order to abscond. You know, I trust the court, and I know the court will dismiss that particular statement, that we did not prove any ownership of a passport by the respondent, because you don't need a passport to abscond, Your Honor. Absconding, it doesn't mean that you must go out of the country. You can abscond even within the same area, and you hide somewhere so that you cannot be caught. So the issue of not them having a passport is neither here nor there. And Your Honor, Counsel Omare, and I hope, say God forbid, because he said a statement before you that they did an application previously saying that the said doctor who left us, may God rest his soul in peace, he had told the court that the said person would die or was in a there are possibilities he could die because of his age.
I'm sorry for interjecting, but I think counsel is mischaracterizing the submissions that were made. I believe the record is clear of the submissions that were made by my senior, Mr. Danis Tamamari. So counsel should just avoid the temptation of mischaracterizing submissions.
Let him finish first. I have the capacity. Let him finish.
Thank you.
Yes, Your Honor. Thank you for protecting me, Your Honor. And counsel said that, or made some statements before you, that the first respondent, being of 75 years old, falls in that category, Your Honor. My question, please. If counsel calls for death upon the client, who will pay him? We pray, Your Honor, that having been said, you find the submissions by the counsel for the respondents lacking merit, being an abuse of the court process, and dismiss it and grant us the 30 days that you're praying for, and to find that our application meets the threshold as set in the list of authorities we have presented, the law, and the Constitution. I rest, Your Honor.
Mr. Kofuna, anything? No, Roberto. Okay, thank you.
Your Honor, perhaps for the completeness of the court record, we had made references to complaints that were filed or were lodged with the police and treatment notes that were issued by doctors. Perhaps we can just supply them to the court so that we complete the court record. Thank you.
Your Honor, one of them is, they say there's no medical report.
It's okay. If you've submitted, it's okay. Have you given them a copy?
Your Honor, we will be supplying a copy. I'm sorry, I only had one copy that had been given to me in a hurry. So, as and when we retire, we shall supply a copy.
So you will make a copy? You have another one? Or I can retain this?
No, you can maintain this, Your Honor. These are just photocopies.
Photocopies, okay.
Yes, and then we'll
okay.
make other copies for the benefit of our
okay.
colleagues.
All right.
Thank you.
Okay, it's been a long afternoon from how many hours? I think 4 hours. Okay. So, I'll give you a date for your ruling.
You can also release them while pending ruling.
I'll make those directions shortly. With a monitor, will do that. What time did you start? With at about noon. It's now 4. Okay, so upon hearing the elaborate submissions by the prosecution, the family of the deceased counsel, and the respondent's counsel for close to 4 hours, this court will render its decision on Monday, that is on 3rd of August 2026 at 3 p.m. In the meantime, the first respondent will be held at Kilmani Police Station, and the second respondent will be held at Kileleshwa Police Station. In the event that the respondents may require any medication, the family members are at liberty to forward the same to them through the OCS of the respective police stations. Also, the respondents are at liberty to contact their respective councils without any limitation. So the orders of the court.
In case you will grant any other days, we want them to these 3 days that until Monday, and I'm finding investigation.
I think Council Shadrach, I think he had also submitted on that. So, thank you. So thank you very much. Have a good evening.